Welcome back to another episode of our podcast. And I've had a few technical issues getting on board, so do bear with me. Today, we're going to be talking all things Employment Rights Act, which I know everyone is very excited about. And I'm delighted to be joined once again by Joanna Sutton from Nockolds. How are we doing, Joanna?
I'm good, Trish. How you doing?
I'm really good. I'm so excited about this. I've literally been waiting to be able to chat through all of this stuff with you because I've got a lot of questions that I want to ask.
Okay, good, good. Well, hopefully I'll be able to answer them.
And response. Well, should we just dive straight into it? I mean, I think
Yeah.
what is really useful whenever you and I talk is it's nice and conversational and it's just easy language and easy to understand. So I feel like this is going to be a good one, breaking down something that could be quite complex. So, what's the big deal with this new act? I mean, the way I see it, this is probably one of the biggest changes in employment law that I've seen in my whole kind of 20-year career, to be fair, but I don't know if that's me exaggerating. What would you say is the big deal about it?
No, absolutely. It is a huge deal, and the Labour government themselves say it's a huge deal. You know, they're billing it as the biggest upgrade to workers' rights in a generation. And as you say, it really is a huge. It's changing pretty much every area of employment law from what has been established for a number of years. There's changes in respect of pretty much everything. So it is huge. And it's also hugely controversial in some ways as well. You know, it's taken an absolute age to get through Parliament
Mhm.
because the Labour government and the Conservative government, as you can imagine, just couldn't agree. And so it's taken a lot longer to get to this point than we thought it was going to. And unfortunately, there's still quite a lot of uncertainty around some of the areas as well, I think, which is not helpful for businesses. So yeah, it's a huge deal, and I know it's something that a lot of employers are really worried about.
I was going to ask you about kind of that back and forth because there was that kind of ping pong period and, as you say, uncertainty. So, what would you say is so controversial about the new act?
I mean, it's not. It's to be expected in a way because the Labour government are always pro employee and the Conservative government will always be pro business. And so when you see a change in government, as we have, there's always kind of a bit of a change of the shift of the power and the focus. And so that was to be expected, but this really is kind of a huge upgrade to those rights. And really, I think to reflect kind of a change in working practices that we've had over the last, 10, 20 years. But particularly since COVID, the way that we all work has changed massively. And really, a lot of it is intended to sort of reflect the way that people are working, but also the government say that one of their sort of main intentions behind it is to give more security and stability and really have laws that help grow the economy. So that's the intention. But yeah, businesses don't like it, and that's because it changes a lot of things. It makes it more onerous in a lot of ways for businesses. It increases the risk of claims, and in fact yesterday there was a impact assessment that the government put out. I don't know if you've seen it, where they've said that they think that there's going to be a 17% increase in employment tribunal claims, and that's their own assessment. And if that's kind of the way they're billing it, I think it's probably going to be quite a lot worse than that,
I was going to say
unfortunately.
17% seems pretty low to me. You're pretty much changing the
Yeah,
way we do everything, and you think there's just going to be that
yeah,
smaller change?
absolutely. Yeah, yeah, it's interesting. So
Mm.
I think they've said that they think the cost to businesses is going to be about £1 billion,
Mm.
which they've specifically said actually that it's going to impact smaller businesses more than the larger businesses because of them having less resources and the additional compliance burden that a lot of these changes will put on. So yeah, that's I think why it is so controversial and difficult for businesses, and employers have not been looking forward to this coming into force.
I think, I guess for me, one of the concerns I've got is how the tribunal service is going to manage. It's not managing right now. So even if you were to put a 17% increase in, which to me is very, I think that's a very optimistic estimate. I,
Yeah.
I still think putting that into the system that we've got now just wouldn't work.
Absolutely. The system at the moment is, I think the statistics say that the number of cases in the system has gone back to sort of COVID levels. But I mean, then, the courts weren't really operating properly because everything was shut down. And I completely agree. The tribunal system is not functioning at the moment. If you issue a case now, it's not going to be heard until at least next year at the earliest.
Mm.
And we have then the ACAS system in place for early conciliation, where you have to notify them before you go to an employment tribunal. They've had a huge increase, I think it's about 25% in the last year, of the number of notifications that they're receiving. And in my experience, cases then were being referred for conciliation, and there's a 6-week conciliation period, but a conciliator wasn't even being appointed during that period. And so no one was even able to sort of try and resolve the disputes, which has led to an increase in them going to tribunal. So to try and remedy that, they have just increased the conciliation period. So it's now a 12-week early conciliation period. But even so, the cases that would normally be resolved through that system aren't necessarily being resolved, which is increasing the number that are going to tribunal. And with all of these new rights and new laws coming in as well, that's going to, as we said, result in a big increase in a system that can't cope already.
Yeah, which is worrying. Okay.
Yes. I
I
mean, there
suppose.
had been talk of bringing back employment tribunal fees towards the end of last year, which a lot of employers got quite excited about. But the government have said no, they're not going to do that. I
Mm,
think all they're doing pretty much is trying to recruit new judges, which takes time.
mhm.
So, yeah, it's a difficult one.
All fun and games.
Yes.
Well, I suppose the saving grace that we've got though is all of this stuff, whilst it's coming, isn't all going to hit at the same time. So I think for me, I was quite nervous initially when we started to hear about the bill when it was in that form of how are we going to cope with all of this stuff in one go. But actually, they have kind of phased it out, which I think is a good thing. And look, I'm pro employees having more rights. I think it's just finding that balance to make sure that we haven't got businesses going to be picking up a bill for billions and small businesses being squeezed and all that kind of thing. It's fun for me. It's finding that balance between treating people as they should be treated and making sure that it works economically.
Absolutely, definitely. And I think the government have been quite sensible in that sense, as you say, in kind of staggering
Mm,
bringing these changes in. There was a lot of uncertainty about, there was all these new rights and it was all going to happen, but no one knew when. And so in the summer, they issued their roadmap where they've given kind of estimates of when all of these new things are going to be phased in. It's over the next couple of years.
mm,
So that's helpful. But yeah, there's still quite a lot of uncertainty because although now the bill has received royal assent and is now a formal act of parliament, a lot of these changes are then going to have to be brought into law, into legal effect by regulations. And so those need to be drafted. And the government have said they're going to consult with businesses and other bodies about the actual final form of what those regulations should look like. And they've launched a raft of consultations which are ongoing at the moment. But that's what I mean about the uncertainty that there still is, where yes, we know the kind of the headline of what the change is likely to be, but we don't know what it definitely will be. And I think that given the delay in the act coming into to becoming an act of parliament, it may be that some of those times have already slipped, and we may see that timeline kind of revisited with some delay. The things that are coming in soonest, which we'll go on to talk about, I don't think will be impacted, but there are some quite complicated changes that still need to be thought through, which we may see pushed a bit further down the line, I think.
no, I agree. Okay, so let's kick off with February then. So we know that February 2026 we're going to see some stuff around industrial action. So in particular, that dismissing somebody for taking part in industrial action will become automatically unfair. So what's changed in terms of that compared to where we were previously, or where we are now, I suppose?
So I suppose the first thing to mention is that the government have also repealed the minimum strike, the strike level legislation. So the minimum service level, sorry, I should say, that had been implemented by the Conservative government, which was intended to place restrictions on essential services striking. That was repealed with immediate effect when the bill came in. When the bill became an act of parliament. So that was an immediate change. I mean, doesn't affect everybody, but it's certainly a sort of a change that has happened instantly, and that was just because they could reverse the legislation rather than having to draft loads of complicated regulations. So that was an easy one for them to do. But yeah, then we've got these new changes around industrial action and automatic unfair dismissal.
When we're
Just
saying industrial action, what exactly do we mean? I mean, that immediately makes me think strikes. Is that what we're talking about?
Yeah, exactly. So it strikes. I mean, you essentially fall into sort of two camps with this. Industrial action is either strikes or action that falls short of a strike, which is stuff like working to rules, so only doing exactly what your contract says, not working overtime, that kind of thing. So yeah, that's essentially what industrial action counts as.
To be, I mean, I might be showing a little bit of ignorance here because I haven't typically worked in environments where there was a lot of industrial action. Do there tend to be lots of instances where employers are letting people go? I suppose what I'm asking is what's the problem that this part of the act is trying to fix?
So it's quite complicated, but essentially what it meant was that it has always been automatically unfair dismissal if you dismiss an employee
Mm.
for taking part in strikes. But there were some quite complicated timings around it. So you were only protected for 12 weeks from the start of the industrial action. So if the industrial action lasted longer than that, then you kind of were timed out for bringing a claim. So what this is changing is basically saying that there isn't that 12-week period. You are protected throughout the industrial action from either being subjected to a detriment or dismissed. And then that protection continues all the way through the industrial action, and then the normal time limit for bringing an employment tribunal claim, currently 3 months, would apply at the end of that. So it's essentially meant to sort of broaden the scope so that there isn't just this 12-week period. I mean, again, some industrial action may not carry on for that long, but if you think about things like the doctors' strikes and things like that, then
Mm.
yes, they have done. So it's really intended to sort of broaden that protection.
Okay, so it almost feels like tidying up a bit of a loophole that maybe a lot of
Yeah,
people wouldn't have known about anyway, but
yeah,
important nevertheless.
exactly that. Yeah.
Okay, alrighty, so let's canter on to April 2026 then. So we've got some quite big things happening in April in terms of this act. So first one is sick pay from day one. Um, this feels like a really big shift for small businesses because if I'm honest, and again it's only my experience, but where I've worked for larger organisations, generally they'll have sick pay apply from kind of day one anyway. Generally, not always, caveat, caveat. But this feels like something that's going to hit smaller businesses more than bigger ones. Would you agree?
Yeah, exactly. So, I mean, this is a big change.
Mm.
So, essentially, at the moment, statutory sick pay is only payable from day 4 of being away from work. So, the first 3 days are classed as waiting days, where you're waiting to see if the employee comes back to work. And what this is proposing is from April that won't apply, and from the very first day of sickness absence, an employee will be entitled to statutory sick pay. So, as you say, for larger employers or people who have enhanced sick pay policy, it doesn't really make any difference. But for those who don't and who only pay statutory sick pay, so I don't know, maybe retailers, that kind of thing, or smaller businesses, um, that's going to increase the cost of employees being sick. And it also potentially will increase the number of employees who are off sick, because currently, if you're thinking, right, well, if I don't go into work, then I'm not going to get paid. So employees may well be sort of struggling into work when they're feeling unwell, when they shouldn't otherwise be going in, because they need to be, getting paid for them working. Whereas now, if they're going to get paid for not going into work, then it could increase the sickness absence, genuine sickness absence, but also the maybe not so genuine sickness absence. You get into the realms of people taking the Friday and a Monday off to get a longer weekend because they're going to get paid for it. So
Yeah.
the cynical part of me says that this could result in increased, well, it will result in increased absence, and some of it may not be genuine, which then is going to mean sort of tightening up on absence management processes and things like that to make sure that it's being monitored, tracked, and dealt with if it isn't genuine.
And making sure that you have an absence management process in the first place, right?
Yeah. Yeah, absolutely. So, some organizations, as you'll know, have that kind of trigger where if you hit a certain amount of sickness absence, then you go into an absent management process, like you use the Bradford score or something like that, which has its downsides as well.
A fan of
Not
just
a,
putting that there.
yeah. Why are you a fan of it?
I just think it complicates it. I mean, I'm not. I'm a HR person. I'm not a maths whiz. I find it hard to understand from a mathematical perspective, and also I feel like it just takes away from having those meaningful conversations and makes it all about the number. Like I'm more
Yeah.
bothered about what's going on for the person. Yes, clearly, like as you were saying, if there are patterns with somebody, and they're taking the mick, and it's every Friday and every Monday, great because it shows you those kind of shorter term things. But I kind of want to know what's going on with the person. I think the conversation is more important than the number. And I suppose
Yeah.
maybe I've just been a little bit burnt in that I've worked for organisations in the distant past, really, that have focused, in my view, far too heavily on that number and not been thinking about the
Mm,
person. But
yeah.
my little Bradford rant.
No, I agree, and I think that it's a risk from a discrimination point of view as well.
Mm.
If you've just hard and that's when it kicks in, you've got an employee with a disability, or say someone's going through cancer treatment or something like that.
Mm.
It's yeah, it
Yeah.
having a one size fits all doesn't always work. So,
No.
but yeah, I think that there would need to be, certainly, as you say, having more of those conversations, like a return to work meeting, talking through, what was the reason for the absence, starting to see if there's patterns, because that sickness isn't always necessarily to do with sickness. It may be because there are domestic violence issues at home,
Yeah.
or caring responsibilities, that the employee could actually access some other type of leave that's available within the organization. So yeah, I think I agree, it's really important to have the conversation and to think about it more from a human perspective rather than a process.
Yeah.
But I think, yeah, monitoring it is going to become more important if the absence is increasing.
Mm, I agree. Alrighty, so sticking with April then, we've got paternity and parental leave becoming day one rights as well. So similar in terms of sick pay becoming a day one right. What kind of practical difference do you think that makes for new starters? Is that one that people should or employers need to be worried about?
I was also just on SSP, just going to mention about the
Oh,
lower
okay.
earnings limit being
Oh,
removed. So,
yes, yes. Sorry, let's go back to that.
um, So, also on SSP, one of the other changes that's coming in April is that the lower earnings limit is being removed. So,
Mm,
currently, an employee is only entitled to statutory sick pay if they meet the limit of what the government set as that lower earnings limit. I think at the moment it's about £125 as of
yeah.
January 2026. Um, so what the government said was, actually, that means that quite a lot of people, if they are unwell, are just not getting sick pay at all, even
Mhm.
after those 3 waiting days. And so what they are doing is removing that limit, and saying that everybody will be entitled to some form of sick pay if you earn less than £125 a week, or whatever the qualifying amount is that they set. Then they're going to pay a percentage. Employers are going to have to pay a percentage of that. So I think what they're proposing at the moment is 80% of your normal earnings, so that then again you're not left with no money at all if you need to take time off sick. And I think I think the stats are that it's going to increase the eligibility of statutory sick pay to mean another 1.3 million people will be entitled to it. So again, additional cost from that perspective for those employers who perhaps haven't had to pay statutory sick pay so far. So yeah, it's another big change from that perspective.
I guess another one where it feels like we're just tidying up things that probably were a little bit scriff in the first place, because that always felt just
Absolutely.
anyway.
Yeah, exactly. It makes sense, doesn't it? And
Mm.
again, perhaps that then reflects the changes that there have been in terms of working practices with more 0 hours contracts or, lower hourly contracts rather than everyone working full time, for example. So I think, yeah, that's kind of the policy intent behind it and does make sense, but uh, as with many of these, not popular with employers.
I have to apologise to you and the listeners because I'm recording from home today, which I don't normally do, but I thought, you know what, we're going to give it a go. My dog is in the background, and I'm not sure whether or not it came across on the sound, but he just fell over a pair of trainers and made a cacophony of a noise. So apologies if that's come across
I
because I'm
didn't
probably
hear anything, but I was
you did.
probably too busy thinking about statutory sick pay. So
Oh, bless you. Okay. Anything else on sick pay? 'Cause I'm conscious I moved us along, and actually that was a very important
no,
point.
I
But
don't think so. No.
no? Okay, fab. All right, so parental, parental and paternity leave. So we're sticking with April. That's going to be day one, right? Do we feel that's a massive, huge shift? Obviously, there was quite a lengthy period of time before you had access to those things previously.
Mm.
My understanding is that the entitlement that you get isn't changing. It's just that the ability to access it. Is that right?
Yeah, that's exactly right. So at the moment, for paternity leave, you have to be working for the same employer for at least 26 weeks
Mhm.
before you can gain the right to take paternity leave, which the statutory is just 2 weeks, so not huge. From April, that becomes a day one right. So the employee doesn't have to have that minimum 26 weeks working for the employer, but the pay and everything else, the amount of leave stays exactly the same. And the same with parental leave. Currently, you have to work for an employer for at least a year to be able to access that, and that's going to change to become a day one right. I don't know about you. I don't really see many people taking parental leave. It kind of tends to be that sort of ad hoc sort of dependence leave if like the school's closed for snow, like it's happening to a lot of people at the moment, or there's a childcare emergency. But apart from that, I don't really see much parental leave being taken.
No, and I suppose I've always got a bit of a bee in my bonnet with paternity leave as well. I just don't think it's long enough. I don't think that's long
No.
enough to be able to, you've got a whole new human, or in my case, I had twins. We had two new
Yeah.
babies, and you got 2 weeks. It's like, get to know your babies, go.
Yeah.
So I do wonder if that's something that they'll look to address or look at again in the future, because it just doesn't quite sit right in terms of the amount of leave that you get.
Yeah, it is actually. It's one of the consultations that's ongoing outside of the Employment Rights Act. But in the
Mhm.
summer, the government said they were just going to do a complete review of the whole parental leave system because, again, it's outdated and it's not. It doesn't reflect modern working practices where maybe years ago, a woman wouldn't have been working and everything else. In other European countries, like Spain, it's much more balanced where, each parent gets 3 months off, fully paid, and they share the caring responsibilities, which again is helpful from the point of view of the gender pay gap and balancing the responsibilities between parents. So I think it's the beginning of perhaps further change that we're going to see. And, as you say, probably reflects better modern life and yeah, would be helpful to many parents out there, I think.
Mm. I mean, this stuff is our bread and butter. So you and I know we were both quite excited when these things are happening just to see all of the changes that were coming in. But it does feel, we're only a few minutes into the podcast. There's so much stuff
Yeah.
coming. And for
Yeah.
those businesses that don't have HR support or aren't able to afford legal support, this feels like a lot and stuff that they can
Yeah.
easily fall foul of.
Absolutely, it is a lot. Even stuff like this, like the paternity leave and things, HR may know about it, but managers won't necessarily know about it. So you've got people on
True.
the ground where, the guys are saying, okay, I want to have paternity leave. And they go, oh, no, you're not entitled to that. And they could be
Mm.
turning down leave requests or, for any of the rest of this stuff, sick leave, anything. So, I mean, yeah, staying up to date with what these changes are is really, really important. And ideally training your workforce about it as well so that they're aware of it. But yeah, it's huge, and that's why I think, as we said at the beginning, the cost and the compliance burden for smaller businesses is going to be so much worse because huge companies have been planning for this for ever since it was announced, and have probably got a whole task force, updating policies and procedures and contracts. And smaller businesses, it may not even be on their radar.
Mm. Alrighty. We're still sticking with April. April feels like a big a
Yeah,
big month in terms of this because
I
it feels like it's
know.
coming
Well,
in.
stuff always changes in employment law, and it's normally like April and October, but April
Mm.
normally tends to get kind of the bulk of it. It's when we see normally stuff like statutory pay rates change, so like when sick pay goes up or maternity pay and things like that. But yeah, it's a bumper April this year.
Mm. Yeah, definitely. Alrighty, so April again, we've got protective awards doubling for redundancy. So it's a case of if redundancy processes are mishandled, then the protective award doubles. For people who don't know what that means, can you explain that in kind of plain English?
I will try. So, protective awards are basically they apply where there are mass redundancies, and so that is essentially where an employer is looking to make at least 20 or more employees redundant. It then triggers a particular type of redundancy consultation process that they have to follow, known as collective consultation, where you have to elect representatives and consult with them, and there's a minimum time that you need to go through the process, so normally 30 days. For where there's less than 100 redundancies proposed, 45 days if it's more than that. You have to go through this process. Essentially, what the protective award is, if you don't follow the required process, it's the compensation that an employment tribunal can award. And currently, it is 90 days pay, uncapped, per employee if an employer fails to follow the consultation requirements. And so what's being proposed from April is that will double. So it will become compensation of a maximum of 180 days, uncapped, per employee if you don't follow the consultation requirements properly. And most compensation in employment tribunal claims is intended to be compensation in the sense of making sure that the employee is put back in the position that they would have been had the thing not happened. So if you're unfairly dismissed and you lose out on 3 months worth of wages, you get 3 months compensation. But this is unusually for employment tribunal compensation meant to be like a penalty to stop people from breaking the law, essentially. So it's not saying that an employee is necessarily going to lose out on 180 days pay, but it's a penalty to try and encourage compliance with the rules. And really that's on the back of kind of big high profile employers not following the rules. So the P&O Ferry case back
Mm.
in, it was 2022, where they decided that they wanted to just employ agency workers who were going to be cheaper than their staff, and so they just announced to everyone they were being made redundant, didn't follow any process at all, because it I think they viewed it as cheaper to do it that way. They knew what the protective award was, and they just decided we want to go through with this and we want to get it done quickly, so we're just going to disregard the law. So you can see then why doubling it and making it even more of a penalty, that's the intention behind it, I think.
And I suppose I'm always frustrated by things like that because at the end of the day, when you're making redundancies, you're dealing with people, and those people have got families and lives and feelings and emotions. So to just be like, I'm just going to disregard the law and do whatever I want, like that, not okay. But you've also got people at the end of the process, and I just think people forget that businesses at the moment, before AI takes over, run with people, right? So we need to treat them with respect, even in those times where it's really crappy and we're having to make redundancies and make changes. Again, I'm on my soapbox again, aren't I?
No, I agree. I mean, I think that with redundancy, and I see it from advising businesses and individuals, it's a really difficult time
Mm.
for both sides. But normally, if you go through the consultation process properly and you explain the reasons why the business is having to do these things, and you talk about the alternatives, and you have that dialogue with an employee, by the end of the process, they understand, why, they've accepted it. Whereas, just doing it this way, without any dialogue, completely blindsides the employees, and it makes them feel much more aggrieved about it, which is much more likely to lead to a claim anyway.
Yeah, yeah, no, totally agree. But hopefully things like this are going to deter people from being P&O fairies.
Absolutely. And I think that in reality, a lot of employers don't breach this requirement. They follow the required law. They normally take legal advice when they know that there's quite a lot of redundancies or restructuring to do, and they follow the process. So hopefully it's not something that's going to affect a lot of employers. It really is just there to deter people from not
Mm.
following the rules.
Yeah, I suppose it's just frustrating that there needs to be a deterrent. Well,
Absolutely, yeah.
then that's me. Alrighty, last for April then. So we're into sexual harassment and whistleblowing protection. Um, so this changes around sexual harassment complaints now attracting whistleblowing protection. So why is that kind of legally significant for people?
I mean, from a very sort of technical employment law point of view, I don't think this is a huge change. I
Mm,
think that actually, if you were complaining about sexual harassment at the moment, or before this change comes in April, you'd be protected as a whistleblower anyway, because essentially for that you have to make what's called a qualifying disclosure. So it has to be something within a sort of a range of categories, one of which is a breach of a legal obligation or a criminal offence, which normally if a sexual harassment has happened, it would fall under that anyway. So I think that from a impact point of view, this doesn't actually really change anything in terms of those people would have been whistleblowers anyway and would have been protected. But what it does do is kind of make that clear to
mm,
everybody who's not like me getting involved in the technicalities of what a qualifying disclosure is. So it really is. This is all part of the government's, agenda to really get harassment higher up the agenda,
mm,
where they want to make it clear that this is not going to be tolerated anymore, and there is enhanced protection. There's other things that we'll go on to talk about that are coming in as part of that. So really, I think it is just intended to sort of signpost it and to make it clear that if you make a complaint about sexual harassment and you are then treated badly as a result of that, or you are dismissed, you will have additional legal protection as a whistleblower, so that people have the certainty of knowing that they can speak out about these kind of things. So I think that's the intention behind it.
Look, we've hit the half an hour mark, although I know it's been fun, so it hasn't really felt like that. So I think, and we've kind of pretty much come to the end of the April side of things. So it's probably a nice point to pause and then perhaps have a part two, which covers everything from kind of October onwards. Is there anything else that you think is useful for people to know about, from here to April before we do that?
No, I mean, I think what I would say is just keep it at the moment. These are the timings that we're expecting, right? And there are regulations that are going to come into force, and there's probably more guidance that will be
Mm,
announced. And some of these big changes, there will be lots of additional work with ACAS and other organisations that will provide further information. So I would just say, just keep a close eye on what's
mm,
happening. I'm sure that if anything changes further, you and I will probably jump on another podcast to chat it through anyway. But
yeah.
um, I think that these are big changes. There are things that employers should be doing now to prepare for them. So looking at policies and procedures and contracts and things like
Mm,
that, and just really sort of mapping out how is this going to impact us, looking at budgets and those kind of things as well. So that's my recommendation. These things are not going to go away, and certainly these things that are earmarked for April are now just a couple of months away. So
yeah.
yeah, now is the time to start thinking about them and not burying
Mm.
your head in the sand anymore, I think.
Yeah, and I think you know what, the best piece of advice I can give is if you're stuck and if you're not sure, then get some advice, because I think the
Yeah.
worst that could happen is you don't understand, you do something wrong, then you're dealing with the stress of employment tribunals, which drag on and on, when actually the most useful thing, and whilst sometimes that stuff costs money, actually you're probably better to get a bit of peace of mind and get it right first time than struggle through and get something wrong, would be my general piece of advice for the universe.
Definitely, because it's so much easier to, to follow a process that you're advised to follow, or do the things that is recommended, rather than try and fix it after the event. So yeah, I completely agree with that.
Well, look, thank you. I always appreciate you giving me your time, and you were very gracious and let me like, blather on for 15 minutes before we started recording. So thank you very much for that. Thank you for your time and your brain, because I know this stuff is going to be crucial to some people out there to try and understand what's going on. So thank you. I really appreciate it.
No problem. Thank you for having me. It's always a pleasure to chat this stuff through, and also see your take on it from an HR perspective. So thank you.
You're always welcome.